you have been the lead attorney in cases involving prosecuting sexual violence. Can you explain how the sex crimes in the respective Uganda, DRC, Rwanda, and Sierra Leone cases you were involved with captured your attention and became critical to your case?
About the importance of the gender-based violence, the crimes of sexual violence that were included in the indictments in Sierra Leone, and the difficulty and ultimately the failure to have that included in the CDF trial. But the Special Court did achieve, I think, very good things in relation to the two rebel trials, the AFREG trial and the AFRC trial. And the most controversial aspect of all of that has always been the charges of forced marriage that you've heard a little about. And even though it's now seen as a good thing and it's being celebrated, at the time there was actually a great deal of controversy about the laying of those charges. Michael this morning spoke about Case Western were always very supportive of us, and that's true, and we were very grateful for it at the time. We had, as is appropriate, a stream of academics and other interested people coming through the Special Court to review what we were doing, to advise us, and to offer constructive criticism about what we were doing. And we were most often criticised constructively about the forced marriage charges. And because they were in the trials that I was doing, I was often wheeled out to defend the policy of the Special Court and the Office of the Prosecutor. And David spoke a little about this yesterday, about how this came about. And when we were reviewing the evidence of sexual violence that occurred in Sierra Leone, and the sexual violence was appalling. It is not possible to find words to describe how awful the things that happened in Sierra Leone were. When the rebels were sacked from Freetown in 1980 and went north into the country, regrouped through the wet months and then came back towards Freetown, which they invaded in January 1999. The women, particularly in the Bombali district, were just subjected to the most appalling treatment. And while people knew about this concept of forced violence, and where does it fit, and is it sexual slavery, and is it not, is it something different? One of the reasons that Adjua Riahi, the Ghanaian lawyer who ultimately suggested that this be called forced marriage, one of the things that was really, really important to us is that the women themselves who had been subjected to this and who survived it made the discrimination themselves. One would say, not I was a sex slave, but words to the effect of or describe the situation. Whereas she was a wife. And other women would say, I was a wife. So a lot of this was not only about us trying to impose legal categories on what had happened, but trying to find a way to honour and tell the truth about women's experiences. And one of the really difficult things, and the thing that we were most often criticised for about the laying of the forced marriage charge, is that it's subsumed within the concept of sexual slavery. And by separating it, what you're actually doing is imposing a status. And a status offence on women has a history of being problematic. And you're stigmatising the women. Because the reality is that there are still women who were abducted, who are living with their rebel husbands now, as we're speaking through. They cannot leave. They have children. And what do you do? And there were these echoes, unspoken sometimes, spoken of women with shaved heads being marched through the streets of France following the Second World War. There was this idea of what are we doing to these women? Because the other complicated factor was, if you were a kidnapped woman, and therefore there is no way that you can consent to anything that happens to you, within that rubric, women would often want to be wives. They choose, if they could, to be the wife of a rebel as opposed to a sexual slave, for the very simple reason that it meant that you were raped by one man and not many. It also gave you a little power. It meant that you got food. It meant that you could sometimes have other people go and fetch the water. So there was this difficulty about not wanting to stigmatise the women, but wanting to reflect the truth of what went on. And that was an incredibly difficult thing to do. Legally, we were criticised because by relying on the other category, are we somehow saying that it's less than items that have their own byline, so to speak. So that was an incredibly difficult decision and one that we spent hours and hours and hours dealing with. And ultimately we succeeded, partly because we had very bright young lawyers like Angela who were willing to look at all of this, and David Craig and others willing to take these risks, but because we actually had the women themselves come forward and come to Freetown and risk everything to testify in court. And people were talking yesterday about, I think it was Fatu, about a child soldier being taken from Ituri to Winter and The Hague. On a similar scale, we had women come from country Sierra Leone to Freetown for the first time in their lives. They'd never seen electricity, they'd never seen an air-conditioned room. We actually constantly had people giving evidence wrapped in a sleeping bag because they were just too cold. So there are all of these difficulties, and these wonderful, brave women came forward. So the sexual violence was a very, very important part of what we did, and it pleases me no end that now that we are very much towards the end of that road, that Sierra Leone court has achieved that in the sexual violence